disqualification specified in Article 62 pertain to pre-elections period. What it does say is that 62 contains both qualifications and disqualifications. Right. Because, and 63 obviously is entirely disqualifications, and 62, which originally was a qualification clause, and because of the violence done to the Constitution through revival of Constitution Order of 1985, D, E, F, G were inserted. Now, because of that insertion, it became a sort of a hodgepodge of both. It became qualifications and disqualifications both, and clause 2 of 62 reflects as much.
In fact, this was my question. And in any other judgment, this has been overruled or...
No, sir, this is a 12-member bench judgment, and this is by 7-5 majority, so it's a 12-member bench judgment, never overruled. But then it does acknowledge that 62 contains both qualifications and disqualifications. A, B, C are qualifications, and then the other four...
As per this pronouncement, Article 62 is only applicable
pre-election state, but so my submission here is that 62, because it contains both, it does apply to pre-election stage. At every pre-election stage, whenever a nomination paper is to be challenged or an election is to be challenged, both theoretically would kick in. My Lord, if I may take a pause here.
Can you come
My Lord the Chief Justice, please.
Can you come back to Khakwani?
Yes, sir.
Khakwani is a 7-member bench.
That's right, sir.
Samila Baluch is a 5-member bench.
That's right, sir.
So, the 7-member bench judgment is not worth the paper it's written on. Either we respect the judges' judgments of the Supreme Court or we don't. Now here it says, number of hearings propose the determination of the following constitutional questions by a larger bench. It is a 7-member bench holding. How could a 5-member bench determine this matter then?
It was to be determined by a 7-member bench.
Isn't this binding on the 5-member bench? Is it not binding on the 5-member bench to answer A, B, C, D?
The 5-member bench...
Or it could be argued, that's another proposition, there are these questions which are incapable of an answer. I cannot answer these questions. Like Justice Asif Said Khosa has held. It's not a dissent that's important. It's an additional note. So how can you just disregard one 7-member bench judgment, either attend to it head on? You can't just say, I ignore these 4 questions, I will decide it myself. You have to say something on Khakwani. You have to say these questions, you want to reframe, these are not properly framed, I don't know, whatever way. But how is a 7-member bench being disregarded by a 5-member bench which has specifically noticed these things? One learned judge had given a very categorical finding on it, and have no discussion in the 5-member bench. So why should we not follow the 7-member bench as opposed to the 5-member bench?
That's
why is nobody insisting on Khakwani?
That's why, my Lord, my submission is that Khakwani, without addressing these, without actually acknowledging the existence or presence of this judgment, goes on to hold that it would be a court of civil jurisdiction, without addressing this question that why civil, why not? And in fact, Khakwani says declaration of conviction. So Khakwani perhaps implies that it could be both instances. Could be a civil declaration, it could be a conviction also, which would both be covered under 61F.
It just raises questions, valid questions.
Yes.
One judge gives an opinion.
That's right.
He said these cannot be decided.
Justiciable nahi hai.
No, but at least Samula does this, that it addresses the question as to what declaration it would be, and they said it's a declaration coming out of civil.
So that again, the Samula overlooks that the 7-member bench actually contemplated perhaps both. The 7-member bench said also
but part to one extent, I mean, to civil only they've come up with some answer.
A part of A that they say that जहाँ पे कोर्ट का बताना था तो उन्होंने कहा कि सिविल होगा. It did not then hold that why not a conviction.
And उसमें भी problem ये है फिर तो अगर if we are so then we stuck on the very basic question कि declaration from a court of competent law क्या है.
That's right, sir.
So
that has to be answered.
So that's not answered.
Yes.
So बाकी सारी चीजें तो दूर की बात है ना कि duration क्या है.
Everything is based on that premise that there is a declaration by a court of law.
So we're assuming on Samuel's argument that there is a declaration which would be between inter-parties arising out of civil jurisdiction, and then as a consequence we'll build into it that the person is not honest.
What would be the effect of that declaration?
And in effect we'll say
the consequence and so on.
I will go another way. I will say I cannot bring myself to disagree with Justice Khosa.
That was very profound.
What we have read, can I not say that? I cannot bring myself to disagree with Justice Khosa.
Could, my lord, yes.
As a 7-member bench member, the others have not disagreed with him. They should have said, we don't agree, this is a dissent you're writing. You're not writing an opinion of the court.
So where does that leave us, Samir?
So, my lord, now I think as a first step, in my respectful submission, as a first step, my lord would have to first hold what court would it be, or what courts would it be, civil or criminal, either or both, which would give this sort of declaration for the purpose of 62(1)(f)(1). What would be the procedure which will have to be adopted for the purpose of that declaration? What is the standard of proof which would be required, both, and then the locus standi?
In Khakwani, the High Court refused to interfere. The High Court refused to interfere for the reason that the High Court cannot go into such
देखना होगा कौन सी कोर्ट्स ऐसे मामलात को देखें, फिर आगे प्रोसीजर क्या हो। अव्वलन तो यही करना चाहिए, अटॉर्नी जनरल कह रहे हैं। जस्टिस जवाद एस खाजा ने लिखा था ये मामला मुतालिका केस में देखेंगे, इसके बाद, मगर ये मामला कभी देखा ही नहीं किया, अटॉर्नी जनरल ने बताया। ऐसे में चीफ जस्टिस ने सवाल उठाया, उन्होंने इस्तफसार किया, किसी ने ये नहीं कहा ये मामला फेडरल शरीयत कोर्ट के इख्तियार में है। इस्लामी मामलात पर दायरा इख्तियार तो शरीयत कोर्ट्स का ही होता है।
रिटर्निंग ऑफिसर समझ लेगा बात को, या आम शहरी समझ लेगा।
मैं अभी आगे आता हूं।
जो खोसा साहब की बात है, मुझे तो बड़ी भारी बात लग रही है। उसमें मुझे कोई, आई एम ट्राइंग टू, इन माय माइंड ट्राइंग टू disagree with it, and I can't bring myself to disagree with it. He's saying you cannot give these declarations full stop. So maybe these are just rhetorical questions. They don't have an answer. I mean, there are many questions you don't have an answer for. This may be one of them.
इसकी एक interesting बात बताऊं.
However, nonetheless, Parliament has understood 62(1)(f) better than us and has formulated something. Okay, fine, good for you, Parliament. They represent the people of Pakistan. They've understood it, they've done it. Now, unless I can then say Parliament has done something wrong, the only thing Parliament says कि भाई आपके 7-member bench को हमने follow करते हुए ये काम कर दिया है. It is more in tune with the 7-member bench judgment, section 232(2) than SAMAA is.
That's right, sir. And मैं थोड़ा सा एक background बताऊं. My lord was originally अभी एक्सप्लेन हुआ कि सिर्फ 3 प्रोविजंस थी, A, B, C था 62 में. When the constitution was being made, certain amendments were proposed by members who belong to religious parties. I'm talking about the original constitution making, at the time of original constitution making. I'll just read out very slowly. I don't have, unfortunately, a copy of it. 2 amendments were proposed, and motions were made, and they were negatived. They were rejected. And if I may read out, they are quite akin to what was then inserted through revival of Constitution Order 1985 by General.
Where are you reading from? Parliamentary debates?
Parliamentary debates.